Okay, good afternoon, everyone. So we have two different IP attorneys to speak with us today. I'm going to introduce both of them, and then we'll launch into the presentation. We have Jonathan Menkes, who is a partner with Novi Martins, and he provides strategic trademark counseling and brand protection for clients across numerous industries. He is also the co-chair of the firm's CBD and legal cannabis group. Jonathan's practice includes domestic and foreign trademark selection and clearance, trademark audits, and notice and takedown procedures involving copyright and trademark claims on social media and domestic and foreign e-commerce websites. David Weiss is also a partner of Novi Martins. David is the founding and managing partner of Novi's Los Angeles office. David's practice emphasizes strategic counseling, licensing, and patent prosecution matters. He has extensive experience in patenting novel technologies, developing strategies to protect a market niche, conducting venture capital due diligence, ensuring ownership of intellectual property rights, drafting of intellectual property licensing and joint development agreements, and dealing with the challenges that face new companies. David's diverse IP practice includes startups, mid-sized companies, Fortune 50 companies, and venture capitalists. He represents clients in a wide range of technologies such as e-commerce, computer hardware, computer software, financial transactions, artificial intelligence, digital signal processing, medical products, telecommunications, and video and audio processing. My name is Catherine Sales. I am a partner at Sislo & Thomas. I too am a patent attorney. I practice in trademarks and copyrights as well. And in a former life, I used to be an embryologist. So you can throw some fertility stuff my way too. Let's get to it. Should we do next slide? David, you're muted.
Okay, sorry about that. So what is intellectual property? It's really anything the mind can produce. Any idea that the mind can produce that is protected by law. And so intellectual property can include books, music, paintings, computer software, electronic circuits, brands, designs, really anything that the mind can come up with. And so why should, entrepreneurs care about IP? And so, IP is often really what distinguishes your business from all of your competitors. It could be you have a better product than your competitors do, additional features. It could be just your branding is more eye-catching and attracts users more. It could be your trade secrets on how to make something that in a better way than your competitors do. So all those things help distinguish you from your competitors, help maybe price your products more expensively and yet still get sales for your products. It just gives many business advantages. Now, IP issues really arise from day one. So it could be, again, because there's timing often associated with protecting your rights. So it could be you come up with some novel medical device. If you don't protect it in a timely way, you lose the right to protect it. With trademarks, and I have seen this, is you don't do proper due diligence to see if you have the right to use your mark if somebody else already using it. And you may find out either right before you ship product or even worse afterwards that you can't use the mark you were using and you have to find a whole new brand identity. And so intellectual property really reinforces your business goals. It helps support your brand. It helps support your technology. And again, it helps you distinguish yourself in a very competitive environment. So, as I mentioned before, and Jonathan will go into more detail on the trademark issues, but trademark clearance, do you even have a right to use the mark that you intend to use? Do you own what you think you own? And often I've had clients who paid for something to be developed, whether it was software, whether it was an invention, think they own it, but they don't own it. They may have rights to use it, but they don't necessarily own it. And then there's IP issues in marketing. So what is a trademark and trade dress? Again, that's probably the IP that people are most familiar with. It could be a company name, a company logo, a company brand, and the reputation, goodwill that goes along with it. So again, if you buy a Rolls Royce, you have certain expectations from the car just because of the brand. Copyrights are an expression of an idea. It could be a book, movies, plays, really anything that is, fixed and that is more than trivial. There's not a high standard for copyrights. And then trade secrets. So every company has trade secrets. It may be pricing information. Again, it may be certain processes. It could be business processes. It could be technical processes. So really, it's anything that has a certain value that people don't generally know. And then there's patents, and that is an invention that is, new and not obvious, directed, towards, it could be software, it could be electronics, could be optics, it could be a better mousetrap. So what do these different rights give you? So patents give you the right to stop other people from making, using, selling, or importing your invention. And doesn't necessarily give you the right to use your own invention, which sometimes is confusing, but gives you people gives you the right to stop people from using your invention. So an example would be, and we'll go into some more detail, but you have a patent on a chair, a seat, 4 legs, and a back. So you can stop anyone from making a seat, 4 legs, and a back. But if somebody else has a patent on the stool, a seat, and 4 legs, you still might infringe their patent. So again, patent gives you the right to stop people from using your invention, but doesn't mean you're not infringing somebody else's invention, somebody else's patent. Trademarks give you the right to prevent others from using the mark that would cause confusion among consumers. And the copyright gives you, again, the right to stop unauthorized copying, distribution, performance of copyrighted works. And then trade secrets, those gives you the right to stop other people from misappropriating your trade secrets. So often when you're releasing a new product, there are many different types of IP that could be involved. So this was from a patent from Oakley sunglasses that had an MP3 player built in from a few years ago. And you can have a patent on having the earbud integrated into the frame. You can have a patent on the lens shape. You can have what's called a design patent, which just protects the way it looks, not the way it works, on the frame shape. You can have trademarks on the logos and on the name. You can have copyrights on the brochures, on the software used to design the lens, and on the lens manufacturing process. So even a simple product, relatively simple product like a pair of sunglasses has many IP considerations that need to be taken into account. When you set up a business, now your company name doesn't necessarily have to be your brand name, but it often is. And so even when you pick the name of your company, you have to make sure, again, you have the right to use that in a way that wouldn't confuse consumers with somebody with similar name company. And when it comes to technologies, again, you may have certain innovations, and there are time considerations in filing for those innovations. So before you release the product, you want to consider whether you should be filing patent applications. Creation materials, you want to make sure that to the extent you're using, especially outside vendors, do you own the materials that you're paying for to be created? Many VCs, they're very interested in intellectual property, depending on the particular technical field. And that often is either a benchmark that needs to be met in order to get any investments, or can affect the terms of the deal depending on how well they think you protected intellectual property and how well you can keep competitors away. And then there's, when you again, all product designs and manufacturers could be protected, both sometimes by patent, sometimes by copyright, sometimes by trade dress, sometimes by all three. And then there's enforcement of your rights. So you have to decide, again, everybody has limited budgets, and everybody has to decide how they're going to spend those budgets on their IP. So I have clients who sometimes fall in love with a technical invention of theirs or with a tagline of theirs, which is terrific. But those may not be really what are business motivators for their company. In other words, if you have some technical innovation that improves something by 1/10 of 1%, you may think it's a great idea, but it's not going to sell any more product. It's not going to let you charge any more for your product. May not be a great way to spend your investment. When it comes to trademarks, I remember one client who in-house counsel, when they hired me, they told me my job was to try to discourage their CEO from filing so many trademark applications, because he would just fall in love with a million different taglines and a million different trademarks and register them all. So that's great if you have the finances for it, but you want to also identify often what are your more important brands, what are your more important marks, and how long do you think you'll be using them. And again, when it comes to like product design, and look, how important is that to your sales? And sometimes the look is really what you're selling. It's not because you have new innovations. It's not because you even have a great brand. It just looks great and everybody likes the way it looks. And you'll have lots of imitators. Some people have clients, their main salesmanship is they've signed on a bunch of celebrities to help promote their products. And that's really what they're focused on. And then it's also even where should you invest? Should you invest just in the United States? Should you invest overseas? And one of the sometimes I think mistakes a lot of startups do is they spend a lot of money investing in speculative markets where they don't have product yet, they don't have partners yet, they don't have any business yet. And again, if you have unlimited resources, that's terrific. But if you have limited resources, again, you need to spend your money wisely. So going to a little more details on patents. So patents, again, investors and bankers and customers like them. It sounds impressive to them. And in fact, aside from being useful for protecting your inventions, lots of people get loans on their patents. It's not unusual for startups when they're getting another round of loans to have liens filed on their patents, and so that's often very important just for their funding. And then, of course, you want to stop competitors from stealing your inventions. You spend a lot of money developing it. You spend a lot of effort on it. You don't want people to just be copying it. And the great things about patents is even if they didn't copy from you, let's say you come up with an invention and somebody else independently later on came up with it. They didn't even see yours. You can still stop them from infringing your patent. So when you have technological improvements, patents are really a critical way to protect them. There are some disadvantages to patents. You file what's called a patent application that typically gets published in 18 months. So whatever it is you've disclosed in that patent application, that now becomes public information. And so often clients need to decide what do they want to protect via trade secret, what do they want to protect via patent. And so certain things, let's say you have a back-end encryption algorithm where you couldn't even tell if somebody was infringing it. And you don't want somebody to be able to kind of break your encryption. So you may want to keep that as a trade secret rather than patenting it. On the other hand, if you have some novel user interface, I mean, as Apple did when they came out with their first iPhone, that everybody's going to want to copy, that's a great thing to patent. You can detect infringement easily, and you can't keep it as a trade secret. It's not possible to, because the whole idea is consumer facing. Patents also only last 20 years from the release filing date. Now, for most inventions, that's terrific. Most of my clients would be delighted with 20 years if their invention was still useful in 20 years. But in certain areas like the pharmaceutical business, sometimes you have patents that could be useful for 30 or 40 years if it was possible, but it's not. Now, if you publicly disclose your invention before you file for it, and I'll go into a little more detail on this later, you may have lost the rights, at least overseas, to protect it via patent. And if you've waited more than a year in the United States, you'll have lost your right to protect in the United States via patent. And as I discussed before, having a patent on invention doesn't mean you're not infringing somebody else's patent. So just because you have a patent doesn't mean that you're not going to get sued for using your own invention at some point in time. So again, you can lose patent rights in the United States from 1 year of the time you offer your patent, your invention for sale, use it commercially, you just disclose it in a paper or at a convention, you'll have lost your rights to protect that invention. You don't do it within 1 year. But for most countries, you actually have to file in the US, if you're a US citizen, before you publicly disclose it. So in the US, if you publicly disclose your invention tomorrow, and then you file the day after, you're still fine in the United States, but you may have lost your rights in most foreign countries. So to the extent that your invention has a lot of utility overseas and you think that there's potential revenue from overseas, you really want to make sure your patent application is on file before you publicly disclose it. And the other thing is, if a competitor comes out with something similar before you file it, even in the United States, so let's say you've been working on it for a year and you haven't filed your application yet, but you've kept it secret. And a day before you file, a competitor comes out with the same product, didn't copy you, but they just came out with it. And I've seen this happen. The day before you file, that will now become what's called prior art to you, and you may not be able to get a patent over that competitor's product. So aside from the grace period, there is a time pressure in getting things on file as quickly as possible to ensure that somebody else doesn't independently come up with it and get ahead of you in line. So again, these are the types of situations where people lose their rights. They do oral presentations. It's not unusual, especially pre-COVID, when people were going to conventions and they were going to show product for the first time, or were going to give a presentation on the product. And I'll get a call the day before saying, David, we need to file a patent on this, patent application on this. So we do what we can in that one day before just to preserve the rights. So that is a very common scenario on losing your patent rights. Publications, and that's very common for universities. So often universities, of course, it's publish or perish, and they license a lot of their inventions, but those two are not always synced up, and sometimes the publication happens before the patent filing, and so that can be a problem as well. Applications, grant applications which are publicly available can kill you as well. So that's the other things. Often, sometimes when clients are putting in even bids for grants or for government contracts and they haven't filed for it, often those bids are still publicly available through the Freedom of Information Act or otherwise, and so you can lose rights to it. Thesis and dissertations, offer for sales, trade shows, testing and collaboration. Sometimes clients will give their product to a potential customer to try out. That may or may not be a bar, and there's a whole area of law on whether that is testing and therefore not a public disclosure, but you don't want to rely on that. So you have to keep all this in mind when you decide when to file for patent application. So ideally, you file before any disclosure. There is something called a provisional patent application, which is a less formal than a regular patent application. It's often less expensive, depending on what you put into it. And so sometimes, as in the case where, again, a client is about to go to a convention and want something on file, we'll put together what we can. We'll get whatever drawings we can get together. We'll put together a write-up. We'll get it on a file. And then you have a year to file the regular application. So when you're under time pressure or financial pressure, these provisional patent applications are often a good way to go. It gives you a year from, at least with respect to whatever you disclose in there, to file the regular application. So, and when it comes to ownership of patents, so the way it works in the US is absent any other agreement, each inventor owns an undivided interest in the entire patent, meaning if there's two inventors, there's no agreement otherwise, either of them can license the patent to anybody they want to, and they don't have to give any compensation to the other patent owner. So that, of course, can be critical for companies. Companies can lose their rights that way. So you want to make sure that with respect to employment agreements, they specify that the company owns all their invention rights for anything at least developed at the company, as well as all their trade secrets they develop, et cetera, et cetera. Same for consulting agreements, outside developer agreements for software, manufacturing agreements, collaboration agreements. Even when you have visitors come to visit you, especially if you're a technology-oriented company, you want them to sign in, you want the sign-in sheet to have certain confidentiality terms in it, even if you don't have a separate standalone NDA. Also, if you have government funding, that can affect ownership interest in the invention, where the government can have certain what's called step-in rights. So, one of the most critical things, again, as I'm sure you all know, all startups need is to have the appropriate agreements in place. And when they come up with new agreements, to make sure it's vetted by somebody to make sure all intellectual property ownership provisions are correct. And so the US in particular is a lot friendlier in terms of to inventors than many foreign countries are, where it goes more by the company or who paid for it. And so often you have to be you deal with a lot of companies who you may collaborate with, who may give input to your invention. It can be contractors, manufacturers. And if they've given you enough input that they become inventors on the patent, then they have that undivided right. So either you need to be careful that you have the appropriate agreements in place, that even if they are inventors, you own their rights to that invention, or you need to be careful not to incorporate their inventions into your patent applications. And so that often comes up too late in the game. So about to file a patent application, it turns out that there were people, outside vendors, who contributed towards the invention, and now you have a rush to get the agreements in place or to rewrite the application to exclude their contributions. And there are times that patents could be owned by multiple people. So again, two inventors can own it, two companies can own it. It makes things messy often in terms of licensing and royalties and such, but it certainly can be done, and it's not that unusual. So in the employment agreements, again, you want to make sure that you own your employees' works, and you want to be very specific about it. We will have an employee, if they claim they came with an invention to the company, we want them to disclose that upon their hiring, so they can't later on argue that it was their invention beforehand. So it's very common in employee agreements to have a listing of saying, please list all your inventions that you had prior to your employment. You also want your employees to maintain confidentiality of your trade secrets, and not just your trade secrets, but third-party trade secrets. Often employees, they're going to find your collaborator trade secrets, and you want to make sure that they understand those need to be protected as well. And so in an employment agreement, it's both kind of an NDA and an IP assignment is what should be included among all the other terms. So it's also important to require them to disclose their inventions to you. It's not unusual. I've had clients come to me who are doing a startup where they had an invention, they developed it at their previous employer, they didn't disclose it to their previous employer, and want to know, can they still build a company around that? And the answer is usually no. And so you want the obligation to be on your employees to tell you if they come up with something, and not just to bury it and walk away and start their own company based on that. And then again, here's just an example, assignment agreement, where it's not just prospective in nature, not just I agree to assign in the future. You want them to say they assign right now all their rights to any invention unless they had come up with it individually on their own time with their own resources. And so California, again, as inventors go, it's a very inventor-friendly state. And so there are certain terms it's good to put in employment agreements that recognize that employees have certain rights under California law to inventions that are truly their own. Some states don't have that restriction, but California does. So trade secrets, every company has trade secrets. Even if they don't have new technology, it may be pricing information, it may be marketing plans, it may be contact lists. Anything really that's valuable to the company that's not publicly known. So again, business information could be your financial data, could be the sales of particular products that you have, technical data, software, processes, really anything. Now, a trade secret is not a trade secret just because you say it so. You really have to demonstrate that you have taken the steps to keep it as a trade secret. So if you don't have, for example, employee guidelines on how to keep trade secrets, if you're not marking your documents as being trade secret and proprietary for the company name, if you're not taking any cybersecurity standards to protect your trade secrets, you'll have a much more difficult time if somebody uses your information, showing that it is a trade secret and that it's been misappropriated. So it's important to do this as soon as possible before the cows left the barn. So again, you want to identify what's really important to you. You want to label everything. Again, the employee agreement should specify it. And the employment agreements also should have, when you should have exit agreements with employees where they acknowledge they've turned in all the materials of the company, they've turned in all the trade secret materials, they don't have any copies, et cetera, et cetera. Use NDAs whenever you can with third parties. We'll keep things locked up. Back in the days when we had things that were physical, and of course, cybersecurity. Be sensitive to employees who have a high turnover rate and may just go away to another competitor very quickly. Make sure you train your employees, not just so your employees will know what is a trade secret and how to protect it, but if it ever comes down to it, to show that you've taken these steps to protect your intellectual property through such training. And it's always a good idea to have one person at the company who's the point of contact for trade secrets, who people can go to if they have any questions, or if an issue arises to implement the response plan on how to deal with a trade secret. So again, whenever you disclose trade secret information, you want to have an NDA in place. And you want to be careful about the NDAs. Everyone thinks NDAs are just a boilerplate agreement, and they really are not. I probably have 15 different NDAs I use with some frequency. And some NDAs are mutual, meaning the parties agree to respect each other's confidential information. But often, really, you're just the one giving the confidential information, and you're not getting any confidential information. So let's say you're talking to a potential investor. You may not be getting any confidential information from that investor, but you're giving away lots of confidential information. So in that case, a one-way NDA that protects your confidential information, not theirs, may be appropriate. There's also, if you're the one receiving confidential information and you're not giving any confidential information, you may want a very weak NDA in place that doesn't give very strong protection. While if you're the one giving the confidential information away, you want very strong protection. So it's not a one-size-fits-all. There are certain kind of standard NDAs that are not bad and that are fine to use, but they're really not the best in every case. And whenever possible, use your NDA. One is because then you don't have to have a lawyer review it again. And two is it will hopefully be more favorable to you than theirs. Sometimes I've seen really egregious NDAs where essentially it'll be from a large company saying, you're not giving us any confidential information. In fact, you acknowledge that whatever you're giving us is not confidential, even though it will have, it'll purport to be an NDA, but it's really an anti-NDA. So you don't want to just sign what's put in front of you. If you are signing somebody else's NDA, you should have it reviewed. And there are times where you can't get an NDA in place. There are certain VCs I deal with, they don't like signing NDAs. They see a million different pitch decks and they don't want to be, they don't want to have to worry that somebody's going to accuse them of stealing their confidential information. I've never seen, and frankly, I haven't seen that issue with at least the VCs I deal with, but they don't want to have any risk in that regards. Or it might be, you just want to pitch a customer and you don't want to slow things down by having to argue about an NDA. So when that happens, if you have no other choice, at least make sure you mark all your, your slideshow, every paper on your slideshow, any handouts you have, confidential, proprietary information, company name, not to be distributed. I put a very short one here, but I have very long notices to put in, where appropriate. So just because you don't have an NDA in place doesn't mean you should give up. There are certain state rights you have to your confidential information, even in the absence of a written agreement. But those will only come into play, again, if everybody understands it's confidential information. If the recipient doesn't know it's confidential information and you've taken no steps to indicate it's confidential, you're not going to get really any protection from the state law. Now, patents, again, the invention, everybody might know does know how it works, and yet you still have patent protection on it. Trade secrets, on the other hand, the advantage is you don't have to disclose what they are to anybody, but if somebody could reverse engineering how your product works, or they independently come up with it, right? They don't know how you did your invention, but they figured it out on their own. Or somehow you inadvertently publish the trade secret, you can lose all those rights. I remember a case I had where a client was using a software developer in India, and the software developer in India would just put on their website all of his stuff. They were just doing it as marketing, showing, look what great software developers we are. But my client lost all their trade secret rights in what was published, because even though it was a breach of terms, nonetheless, they lost all their trade secret rights in what was published. So again, the advantage of trade secrets, if you can keep it secret, it can last forever. So there's the famous Coca-Cola formula, WD-40, to all the handy people out there who it's a lifesaver. That was kept as a trade secret. And even the New York Times book review, how they pick their bestsellers, that's a trade secret. Nobody knows how they do it. And Coca-Cola and WD-40 have not taken any steps to patent their invention. Of course, it's way too late now anyway, so they've kept that as a trade secret. But if somebody misappropriates it and publishes it, you really can't recover it. You may be able to sue them for damages, but they may not have any money to pay you. And at that point, anybody else is free to use it. Doesn't stop somebody from coming up with the invention themselves. And investors and bankers, they don't know how to quantify a trade secret often, right? They don't know if it's going to get stolen tomorrow, or if somebody will be able to independently come up with it. They can't file liens on it to secure their investments or loans. So that's the disadvantage of trade secrets. So, so for trade secrets and patents, you really need to think about, can you detect infringement? Will people be able to figure out how your invention works easily? And if they can, because I know people who do want to keep it as a trade secret, but it's a consumer-facing product, people are going to figure it out very quickly. And so that might be more appropriate for patent protection than trade secret protection. And Jonathan's going to cover some of this also in terms of with respect to copyrights. So certain types of, so whenever you're using an outside vendor, you want to make sure you own what they are doing. Under US copyright law, if you don't have the appropriate language in place, if you're using an outside vendor, even though you paid for it and have the right to use it, the vendor may own the copyrights in what you're doing. And you may not even have the right to modify what you were given. So for certain types of works, you can have what's called work for hire language. And that can cover, drawings, music, photographs and such, and you can say that what they're doing is work for hire for you. And that will give you ownership if it falls into certain categories listed in the Copyright Act. Software generally is not considered, does not fall in those 9 categories. There's some case law that says it does, but most case law says it doesn't. So for software, saying it's a work for hire is not sufficient. You really need to have assignment language. And even in the cases where work for hire is sufficient, it's always a good idea to put in a fallback. Like, this qualifies as work for hire, and in the event that it doesn't, I hereby assign my rights and agree to assign my rights in whatever the invention is, whatever the artwork is. I never rely just on the work for hire language. And one problem I've seen sometimes when entertainment lawyers do this, because most of what they deal with truly are work for hire kind of works. But when you're in the technical field, it's much more common for things not to qualify work for hire. And so you really, in those cases in particular, need to have the assignment languages. So, when you're marketing, you want to put people on notice on your intellectual property rights, other than your trade secret rights. So one is, and again, Jonathan will go into this, you want to mark all your trademarks as TM if it's unregistered or OR if it's registered. You want to be kind of consistent in your logo and the coloring and the style. If you have patents on it, you want to mark your products with the patent numbers. And in the United States, and I don't want to get too deep into this, but if you have a product and you don't put your patent number on it, then you won't be entitled to damages until the infringer is actually on notice that they're infringing your patent. So if you are selling a product, you have a patent on it, somebody else copies the product, and you didn't have a patent number on it, you can't collect damages until you've told them, hey, you're infringing my patent. So it's important to mark your products with patent numbers. It's important to get releases to the extent that you're doing any copy, whether it's stills or movies or videos. Again, it's not uncommon for us to have to do a cleanup where we have to go chase down all the models or actors way after the fact and try to get releases from them. And a lot of these issues in terms of releases and such and assignments, those often come up actually when you're getting either investments or when you're selling the company. That's when due diligence is done on your company. That's when there'll be an attorney such as myself who's going to go look through all the different IP that you have and make sure that you actually have the right to use it and the right to, and you have ownership rights in it. And so you don't want to be stuck at the 11th hour having to try to find all your old vendors, all your old talent, and try to convince them to sign these agreements, assigning rights, which I've done on numerous occasions. And most people are actually agreeable, surprisingly enough, but sometimes they're not. And then you can have real serious ownership issues. Don't put a patent number on something on a product that the patent doesn't relate to. Sometimes you'll see people just slap every patent number they have on every product that they have, and that's not appropriate. Don't use competitor logos without their permission. Again, you'll go on to lots of websites and you may see lots of competitor logo, not even competitor logos, but lots of logos on it that they don't necessarily have the rights to use, or they're using old logos that are not the ones that companies want you to use. Again, don't use obviously photos of celebrities without the permission of celebrity and the photographer who owns the photo. Again, that's actually a fairly common problem. People on their website will be posting photos of celebrities and such, sometimes wearing their products. And even if you have a right in certain cases to use it, you're still inviting a lawsuit. So that's it for me. If anybody has any questions on that, I can answer it now.
Yeah, David, I see a question in the chat that says, in California, do you need an employee assignment instead of work for hire agreement?
So things done by employees are generally considered a work for hire. And you don't need to say it's a work for hire for an employee. But what you still should have is a IP ownership provision. So really, as a standard in all your employment agreements, you don't want to have to think about it. You just want to state expressly that anything they've come up with at the company or based on the company's confidential information, any works of authorship they created at the company. Again, it's either a work for hire or they assign it to the company. And you just want to, belt and suspenders. I mean, that's what lawyers do, and there's a good reason for it. So that way you don't have to address a particular case. You try to come up with language that will cover really whatever the scenario is.
Great, and we've got one more. It says, does work for hire imply employment in California? And if an independent contractor, is it better to use an assignment?
Yeah, so work for hire, there's always that's a very good question. Just saying it's work for hire doesn't necessarily make them an employee under California law. You often will qualify it for copyright purposes as work for hire, may expressly state that it's not, for other purposes. But nonetheless, if at some point the state or the contract wants to argue that they were really an employee, work for hire terms are certainly not going to help you in that regard. But a lot of what goes into work for hire is not just the magic terms. It's also, were they working at their own facility, at their own time, using their own tools, without day-to-day direction from you. So if you have a contractor who actually is working at your, in your offices, who has to come in at 8, has to leave at 5, who's using all your computers or whatever your resources is, who you're really managing like an employee, they're likely to be treated as an employee by the state. And if it says if you have work for hire, that'll just make it even that more likely. On the other hand, if it's a software developer and you're really just giving them like a specification, this is what we need to do. You meet with them every couple of weeks to make sure things are going in line. Again, work for hire really won't work for software, but they're truly not being treated like an employee and they're not an employee, then using the language work for hire, I don't think by itself would have them treated as employees. But again, typically we'll have in those type of agreements, we'll say you're not an employee specifically. And when, you're responsible to make sure you have your own insurance, you're responsible to make sure you're paying whatever withholding you need to pay, et cetera, et cetera. So we have the agreement will specifically say they're not employees, which itself, doesn't mean that the state won't consider them employees. But usually in totality of the circumstances, again, if they're truly working on their own, just doing a project for you, they're not going to be considered employees.
Great, that's all I saw on my end. Jonathan, on to you, I think.
Terrific, terrific. Well, again, David, thank you so much for that wonderful introduction, the overview, and I feel like you've made my portion of this very, very easy. So what I'm going to do is make sure I'm sharing my screen. And while I'm doing this, I hope I can multitask. I love entrepreneurs, and I love them for good reason. My brother is an entrepreneur. He also is an entrepreneur who works in LA. He worked as a visual effects graphic artist for years, 2 decades or so, got a little bit burnt out, said, I want something new, and decided that he was going to quit his job as a visual effects graphic designer and instead make chocolate full time. And lo and behold, it's actually very good chocolate. He has no idea I'm saying this, but I figure might as well. He's my older brother, very proud of him. He's won awards from making his chocolate started in his apartment. Now he has a commercial kitchen. It's off of Robertson and the 10. So if anyone's in the area, please do feel free to stop by and say that, yeah, I saw this presentation with your brother Jonathan, and yeah, it was okay, but I hear your chocolate's really good. But I think it's important because the things that entrepreneurs deal with are different than the things that multi-million-dollar corporations deal with. Certainly funding is a huge issue, and the things that we're talking about today on the trademark side of things play into that as well. Just thumbs up if Catherine, can you confirm you see my screen? Does it show? Excellent, excellent. Very good. So we're going to dive right into this. As David teed this up so nicely, what are trademarks? They tell you the source of a good or product. The whole purpose of trademarks, if there's one thing that you can remember from my section, is trademark. It's used in trade. It's commerce. It's you go to the grocery store, you're looking for something. The trademark laws are created to prevent consumer confusion. They want it to be the case that when you're looking for a product or service, you see a mark, you understand that it comes from one particular source. So I'm sure you're all familiar with these three trademarks here. Probably a number of these as well. We're going to go into the do's and don'ts. First, the don't. Everything to the right of that red line, don't pick a mark that is generic. And what does it mean to be generic? A generic term, it's not even a mark. A generic term is a word or the service itself. It's the product itself. Escalator used to be a trademark, but now when you say the word escalator, you don't think of a particular company that makes those rising stairs in malls. Instead, anyone could make that. There's no source identifying feature to that word escalator. Stay away from those terms at all costs. I would love it if everyone stayed to the far, far left or close to the far left on this screen. Fanciful, coin, we'll go into this, or arbitrary. Unfortunately, what I see with every client, perhaps more so with entrepreneurs than others, this is not your fault. It's okay. It just is a nature that with perhaps limited funds, you'd like to not have to market as hard. So what one might do is they say, well, I'll pick a descriptive mark because then I don't have to explain what I'm doing on my website or what my product is. That does accomplish that goal. You can get your product out there, but unfortunately, from a trademark perspective, it's really difficult to protect, and it's even more difficult to enforce. So that's the trade-off. Again, I'd love it if we protect marks that are stronger. An example I have here: American Airlines. Believe it or not, an airline company that flies across America. Not the most distinctive trademark on the screen here, but over time you can get what's called secondary meaning or acquired distinctiveness. Some other examples you may have seen: 24-hour fitness. Over time, when you see that sign on the freeway, you realize, oh, that's one particular facility. I know it's not, that doesn't refer to any gym that's open 24 hours a day. There's one particular company that offers those services, and therefore it's acquired secondary meaning and can be protectable and enforceable. Working our way up the ladder, as we'll call it, suggestive trademarks, such as Microsoft, Whirlpool for washing machines. There's some thought or imagination that takes place between the trademark and then the underlying product or service. Microsoft for small, micro meaning small, soft for software. There's some connection, mental gymnastics, we'll call them, that you have to get to the trademark. Those are good trademarks. We like those as trademark practitioners. When you're trying to register at the US Patent and Trademark Office, you don't have to show secondary meaning as you would with descriptive marks. And it's much, much better to pick a mark that's at a minimum suggestive, preferably arbitrary or fanciful. So what is an arbitrary trademark? An arbitrary trademark, very strong trademark, is one that it's a word that's known in the English language, and there's no connection between the underlying product or service. So Amazon.com, originally for books, there's no connection. It's not like the books were made in the Amazon or shipped only to the Amazon. No, they were shipped for pretty much everywhere, and certainly now everywhere. But Amazon doesn't describe anything for the underlying products or services that Amazon offers. So it's a fantastically strong trademark. It's an arbitrary one. These are the types of marks we look for. Even better, if we can get it, I'll take it. I only have maybe one out of hundreds of clients who is in the fanciful or coined spectrum here. So don't be sad if you're not quite up in that spectrum, but it's okay. These are made up words. Haagen-Dazs, which frankly, I didn't know until recently that was a made up word. I actually thought that was someone's last name. But ExxonMobil, Google, made up words, very, very strong. These are the types of things that we want to choose when building a brand. It's easier to register, easier to clear. If you make up the word yourself and it doesn't sound like anything else, you're less likely to run into issues than if you pick something on the suggestive or even worse descriptive phase. So what types of trademarks do we have out there? There's designs and logos. Certainly people know the Starbucks, Monster, Nike, etc. They could be words or letters. What you may not know is non-traditional trademarks. I have no idea if the audience will hear this. You probably don't need to, though. If that's sorry if that's terribly loud. It's in my, I think I lost my hearing. My particular microphone, but my headset. But the MGM roar is actually a trademark, one of the oldest sound marks that I'm aware of, frankly. Trademarks, non-traditional, can be slogans. My favorite is actually on this next page. Trade dress. David talked about this a little bit, but I bet if everyone's looking at that box that's in the upper left-hand corner, it's blue. More specifically, it's Robin's Egg Blue. You probably have a guess of what company makes that jewelry. You don't have to, there's no writing on it. You can't see any trademark on it, but you know that that's Tiffany's jewelry because they've done a fantastic job of marketing it, promoting it, and protecting it. Same thing with the Coca-Cola bottle. If I took out the words Coca-Cola, I'm pretty sure all of you would know that's a Coca-Cola bottle just based on the shape. And then, of course, the Levi's jeans here. You can't really see Levi's very well, at least I can't. But the placement of the red tab and then the stitching, these are all source identifiers. So trademarks are lots. I love my job. Trademarks are so much fun. I've really gotten into trade dress and configuration marks the last year and a half or so. I don't know why my clients are all of a sudden deciding to file them, but I'm so happy they are because they are so fun. And then finally, smells. Did people know that smells can be a trademark? They can. If there are any guesses as to Verizon, and they have a trademark or had a trademark until recently on the scent of their stores, in-person stores. And if you guessed flowery musk, you would be correct. They had a registration. You submit a little vial to the USPTO as your evidence of use, and they store it somewhere, and they have a protection. Had protection. They recently lost it, as I mentioned, but up until very recently, had protection on the smell of their stores. Le Vion, they sell jewelry. Theirs smells like chocolate. It's kind of an arbitrary, or there's no connection between jewelry and chocolate. It's a nice scent, certainly, but there's no immediate connection between the two, and so you can have protection for that. Now, a chocolate store that smells like chocolate, not so much. That describes the underlying product or service, or is very connected, so you're not likely to get protection for that. But anyhow, again, trademarks are so much fun. I could talk about them all day, but I know time is short, and I'll definitely be sure to leave plenty of time. And feel free, keep the questions coming. I'll stop at different points in time to answer those. When you're selecting a mark, it's your choice. You're the entrepreneur. You came up with the product, the service. You can call it whatever you want. Again, please call it something, name it something that's arbitrary or fanciful. That would be great, or at worst suggestive, but please, please, please don't pick something descriptive. Also, don't pick something that's already out there. Certainly running a search on your favorite search engine, doesn't have to be Google. Just see, are there other companies using this name? And if so, check them out and see what industry they're in. And don't pick a name that sounds like them, unless you'd like to hire David, myself, or Catherine, because that's what you'll be doing to defend you against the cease and desist letter. Again, I've had rebrands. It's so much more expensive to rebrand after you've launched your product, you've gotten traction, than it is just to do some due diligence up front, figure out if this mark that you're thinking about is in use. The USPTO database is excellent. They've got amazing resources. What is the trademark? What is the timing? What are the fees? How do I search the database myself? Certainly we have expertise with that, but if, again, with tight budgets, you want to do just the initial searching yourself, absolutely use the USPTO's website, and definitely take advantage of all of those resources. How do you protect a trademark? David alluded to this earlier. If you have if you're using the trademark, and it's not yet registered, use the TM. If it's a trademark, you can use TM in pretty much every circumstance. SM is usually reserved for a service mark like a restaurant, but use TM, that's perfectly fine, doesn't cost anything. It's just 2 extra little fonts on your website or packaging. And it's a stay off the grass. It's a great way to tell people, hey, I think I have trademark rights in this product or service, so be warned. But do not use the circle R unless and until it's actually registered. It's a big no-no to use circle R for a trademark registration, claiming you have trademark rights when you don't. Certainly claiming you have trademark rights on products or services that you don't actually have covered is also a big no-no. So just remember that, if nothing else from this particular system. 2 points here. When you file your trademark, you can either be, you launched your product 6 months ago and you've got great evidence from your website or on packaging. Great, file as a use-based application. You just need to provide your first use dates, provide the evidence of use to the trademark office, and you're good to go. An intent to use application means I haven't yet used it, but I plan to use it soon. I have what we call a bona fide intent to use in the near future. Near future could mean a year, could mean a little bit more than that, but if it's, I might use it in 5 years from now, it's a little risky to file an application as an intent to use, because there is case law to suggest that if something that's that far out, do you really have a bona fide intent to use it in commerce? And so the trademark office and trademark law does not like you to reserve trademarks. So just because you come up with a great trademark name, but you can't necessarily, you don't have the resources to file for it at this point in time, I don't just file it if you have no intent to use it. Again, in more than 2 years, probably best to just wait, save that, and just use the TM in the meantime. We'll skip the foreign stuff. We can come back to it if time. Why bother with the registration? I get this question all the time. It's a good one. It shows you own the mark. Once you have that registration on the primary register, it shows you own the mark. It's valid. It's as though you've used it in every state in the US, which is great because maybe you've only shipped or sold product in 2 states, but because you have a registration, you basically locked it in all 50. Very helpful for a cease and desist letter. After 5 years, you get what's called an incontestable status. It doesn't mean it's indestructible. I wish that were true. It's not. Incontestable just means the grounds with which you can challenge it are narrowed, but I'd still rather have that than not. So again, really important to consider registering or filing sooner rather than later. And this last one I think is also very important for products, of course. Once it's registered, you can record that registration, and this applies to copyright as well, with US Customs, and they basically will act. I have faith that they're doing their job, that they will act as a gatekeeper from importation of infringing goods. There's some trainings you could do once the budget allows for it. If your product has unique packaging or some other identifying feature beyond just the trademark, and you'd like to educate them how to spot a fake, the big brands do that. They go to customs, the different ports, and they train them on here's what a real X product looks like, here's a fake one, and they're happy to do that because that's helping them do their job. Okay. Take a brief moment here. Looks like, should I stop here quickly before we say, how do you lose a trademark, to the question that go to that? Let's see. I see this, so I can, is an imprint used by a book publisher as a trademark? Can it be both? I'm not sure I understand the imprint piece. But Catherine, maybe.
And I'm not sure either. So maybe we'll wait and see if Richard types another answer.
Richard, if you could clarify what exactly you mean, but we're happy to, please keep the questions coming. So I just not quite understanding that question, so we'll go to the next one. What an average, go ahead if Catherine you want to ask, and I'll not read it.
Sure. Okay, so what an average client should expect to pay for a trademark registration: attorney's fees, government fees, and other expenses.
All in. I love it. It's a fantastic question. It depends on the law firm. It really does. I mean, and you get what you pay for. Frankly, there are services that I will not name that are very inexpensive, that also don't do the deep dive that a firm like Kenobi Martins would do. So we're not talking tens of thousands of dollars. We're talking substantially less than that, but we're not talking a few $100s. So something in between, you could expect to pay that. I'd budget it. It's absolutely worth it. I have to justify my job, so of course I'm going to say that, but you will often spend more money fixing problems that happen early on than if you just hire someone reputable and get it right the first time. So sorry for not giving more specifics, but we're happy, of course, afterwards to talk about that. So
yes, and I will second that one. The unnamed other options keep us quite busy because we spend a lot of time fixing, to the extent that we can, fixing issues that may have arisen previously. So while it may be more economical up front to go those other routes, you certainly pay for it on the back end, is my experience.
Absolutely, absolutely. So, and that's great to go over that, but maybe 1 out of 100 doesn't need the big law firm name. Maybe one client out of 100, fine, but the vast majority, just there's so many issues you could get tripped up in, and we'll try to talk about some of those. Listing the wrong entity name. There's an assignment that you filed in the, again, we'll get to that. Great questions. All right, well, how do you lose trademark rights? So we talked about how you select a trademark, how you would go about protecting it. Well, a few ways you can lose it. One would be you don't police it at all. So now you don't have just one person using it or a handful or small number of would-be infringers. The entire public refers to your product as generic term. It's now in the trademark graveyard. So escalator, as we talked about, if everyone refers to escalator for the product name itself rather than the source, you're really risking going into the generic land, and we don't want that. So enforcement is key, policing. And this is really tricky, especially for entrepreneurs, because how on earth, I get this all the time, how on earth am I supposed to enforce every single infringement I see online? But when I barely have, I have one trademark and I just don't have the budget and the resources. I'm a small company. I've got like 5 employees. So it's a fair question. And there are ways that are less expensive than a all-out lawsuit to enforce. And that's one thing I specialize in is online takedown requests. By and large, most infringement, of course, happens online. There is, yes, infringement that happens in brick and mortar stores, but most of it's online. And so there are ways that you can submit takedown requests to notify said e-commerce website. Hey, here's this listing. It looks real, but it's not. Here's my registration number. Please take it down. Not terribly expensive. Frankly, I'm confident all of you could submit these yourself. And that's an inexpensive way to help police your mark. So that's one thing I'd add to remember. So police your mark. You can't just stick your head in the ground and do your thing, grow the business. You have to be watching. There are different services that they offer, that our firm offers and that many firms offer to help with that. At a minimum, Google alerts, if you type in your trademark and you just want to know anytime that word is mentioned in the news, it's free. You get it in your email as often as you want, once a day, 100 times a day, once a month. It's free. And it'll, every time that term or mark comes up in the news, you'll see it. And that's an easy way to, and a free way of tracking that. So before I digress too far. Okay, we talked about policing, trademark usage, improper use or lack of use if you just stop using altogether. Certainly if it's 3 years, there's a presumption that you've abandoned it that is rebuttable, but certainly if you stop using it for 5, 6, 7 years, then that trademark is probably gone. There are some things you might be able to do, but by and large, you have to use it or you lose it. Unlike patents and unlike copyrights, trademarks can last forever. As long as it's used in commerce, publicly, then you can maintain trademark rights. These 2 other points here, if you use the mark to describe a product or service, the feature, it really hurts your case for how strong your mark is. It pushes it down to the descriptive level, if you will. And then genericness, as we talked about, we want to avoid that. I think these will all be distributed to you all after the presentation. This video is excellent. It's on Velcro. Their attorneys did a fantastic job of making a video and reminding people why not to call it Velcro, call it hook and loop. You be the judge of whether that's the appropriate usage or not, but it's a fantastically funny video. Okay, pause there. Are there questions before we move on to copyrights?
Yes, we've got one other one from Don. He says, if a trademark was done for a company by a vendor who had no work for hire agreement with the artist, should the artist retain ownership?
Was the trade? Okay, so it's a great question. I'm going to break it apart because there could be a few things going on with this particular question. When you say the trademark was done by a vendor, what you might mean is that the logo that you are now using as a trademark was done by some third party. And certainly David could speak to this as well, but the ownership is key. We'll get to this in copyright, but for trademarks, the first person to use it in commerce owns it. And so if the vendor is just creating a graphic that you'll later use for a trademark, that is actually a copyright issue, more so a little bit of a trademark issue, but that's predominantly who owns the right to that logo, whatever you want to call it, and who can use it. Well, whoever uses it first in commerce has trademark rights. But if the vendor technically owns it because they created it, you'd want an assignment agreement, as we talked about, just to ensure that you own it. Hopefully that answers that question, but I'm happy to loop back if it did not. Great question, though.
Great. That's it that I had open. We're still waiting for Richard to respond about the imprint question.
Sure.
If you'd like clarification.
And we can come back to it certainly. So I will plow ahead then to what is a copyright. David did, again, a fantastic job teeing this up for me. So thank you, David, for making this part so easy. Again, trademark used in trade, used in commerce. It's to prevent consumer confusion. You want to build up goodwill in your company and your brand equity. A copyright is a little bit different. It prevents unauthorized copying, as the name suggests. And again, it could be music, artwork, films, books, poems, choreography, all of these things. It's really the arts writ large, copyright. And one tricky point that I think is worth mentioning, because it comes up all the time, is can the same thing be a trademark and a logo? So we had the Starbucks logo, as you all remember. That's actually both a copyright and a trademark when it's used on signage to indicate where a particular Starbucks store is. That's a trademark. And then if you see Starbucks on t-shirts or the mugs, that's copying on different merchandise. That's copyright. So the same logo can be both the trademark and a copyright. And that's pretty interesting because, as we'll talk about in a moment, copyrights are limited duration, trademarks are not. We'll get to that. Okay, so copyright, really we're protecting the author's expression. It's not the idea. I can't come up with the idea of two people falling in love. The parents really don't like it and try to stop it, and then they end fatefully in the end. So the idea is not protectable, but the chapters, the scenery, the paragraphs, all put together, that's what's protectable in copyright. So one point I'll add on this is short words and phrases are not copyrightable. That's trademark land. If you're trying to use a short word or phrase, a slogan, you're pushing it to trademarks versus copyright. If you're writing a paragraph on your website to explain what it is that your product does, that's copyright. The text, images, all of that is fair game for copyright protection. As we mentioned, graphic, pictorial, sculptural, audiovisual, music, choreography, literary works, computer programs. A significant part of my practice is in software copyrights and then websites. I think websites are by far the most common copyrights that I help clients protect. So what does it help you do? So reproduce, that means copy. You have the right. The owner, so that's the person who came up with this, the author rather, has the right to reproduce, to make adaptions, to distribute to the public, and to publicly perform it. What is the exception here? Well, if you've ever wondered why is it you can go to a bookstore, purchase a copy of a book, read it, and then 2 weeks later sell it to someone else and not be sued for copyright infringement, well, it's this exception for the first sale. Once the copyright owner has made the first sale to the public, any subsequent sale that's thereby made is permissible. You can distribute it to the public, and that's why we have that secondary market for such things. An exception to that, and I'm sure David could talk about this as well for hours, which would be great, is software. When you license software, you don't own it. So this exception does not apply. Very interesting. Could have a whole topic just on that. Okay. Transferring copyright, again, this probably goes without saying, but I've actually heard people ask this, so I think it's worth mentioning. I buy a book. I do not own the copyright in the book. I own the physical book. I pass the book to someone else. They don't own the copyright. They own the physical book. Simple as that. If I own the copyright and I'm transferring it to someone else, it needs to be in writing and signed. We can't just have an oral like, oh, I agree to sign my copyright to you. That doesn't work. The number one thing I see in entrepreneur projects is they say, hey, Jonathan, you don't have to worry about the assignment, Jonathan. I got it. Whoever it is, independent contractor, web designer, marketing person, they assign the copyright to me. I say, okay, can you please send me the agreement? And 9 times out of 10, the language is insufficient to transfer the copyright. So don't trust whoever it is that says they're transferring it. If you get it online, definitely double check it, vet it, because you want to make sure that you get what you pay for, you own the copyrights. Very, very important, especially when you go big, which you all will. Okay. Authorship versus ownership. We alluded to this earlier, but and David again mentioned this, but I think it's worth repeating just because it's so important. The author under the Copyright Act is the person who writes the code for the website, takes the pictures for the website, takes the pictures for the product, what have you. If that person is not an employee within the scope of a company, then that person, this third party, owns the copyright. And in order for you, as the entrepreneur owner of your company, who wants to own this IP, this copyright, you need an assignment. Again, it has to be written and signed. Joint authorship. So if you have a situation where several of you get together, I keep using websites because, again, that's my space. One person writes some of the code for it or some of the text, someone else takes the picture, someone else creates artwork. If all of these things are meshed together, all three of you came up with this website, and they're all intermingled in a way that you can't really pick out, who did what, or it's just intended that you're all contributing together, then you probably have a joint ownership issue. Now, if you're all employees of the same company, less of an issue. And what sounded like a distinction with patents is the joint authorship, where in copyright, you can actually license, if you're truly a joint author, you can license without consent. I do think you need to give an accounting to the other joint authors, though. A quick note on this, you can even see it in the bottom of the slide, copyright 2022. It's the year publication. When you first put this on your website and you intend it to be distributed, that's when you would put the year and the company name. There are a few ways to do this. It's not critical anymore. Thankfully, the Copyright Act no longer strikes your copyright if you get this wrong, but it's still nice to be consistent with your usage there. I'll fly through this. How long does the copyright last? Life of the author plus 70 years if you're an individual, or if it's a company or work for hire situation, it's the lesser of these two, 95 years from publication or the creation date. We don't have to worry about the pre-78 and renewal period. But what's interesting, what I love about this is on January 1st, 2024, we'll see if this happens. I don't know if it'll happen. And I think we could take a poll and 50% of the IP lawyers would say, I have no idea if this is going to actually happen. Steamboat Willie is supposed to fall into the public domain. We don't know if Disney will let that happen, but it may happen. And by 2031, which feels like forever, Superman, Batman, Snow White, Looney Tunes will also fall into the public domain. Again, we shall see. There have been a few extensions over the years where these works were supposed to fall into the public domain. They didn't, so that's why I say it with a little bit of sarcasm that we will see if this date comes and goes and they actually fall into the public domain. Very quickly, but this is important, so maybe I shouldn't go so quickly. Why would you register for a copyright? The primary reason is that you are entitled to statutory damages and attorney's fees only if either you happen to register before infringement happens, or the more likely scenario, or hopefully you would do this anyway, register within 3 months of the publication of the work. So you have your product, you're about to distribute it. Maybe you do distribute it, you have trade shows, you're selling, giving away the product that has the copyright on it. Within 3 months, you should run off to the Copyright Office and register it, preferably the same day if you can. Otherwise, you're only going to get attorney's fees and statutory damages if you register before that infringement happens. So bottom line here, register early, register often. It's per work, which can be pretty significant, as you see here. Willful infringement, up to $150,000, of course, within the court's discretion, but that's no small sum of money, nor is the $30,000 for a normal infringement. That's not willful. One point here worth calling out, you own a copyright the moment it's fixed in a tangible medium of expression. What does that mean? You take the photograph, you write the book, the screenplay, whatever it is that you've saved, if you will, or if it's digital, the copyright's valid and you own it, fine. But to sue on that, you have to register. So it's again, another reason to register. You can't sue until you have a copyright registration. Registration gives you presumption of validity. And again, this attorney's fees and statutory damages is huge, especially when writing a cease and desist letter. Even if you'll never sue anyone, and hopefully none of you have to, almost all of you will at some point in your careers have to either yourself or hire an attorney to send a cease and desist letter. And it's much, much better to have the statutory damages provision for compliance versus not. I know we went very quickly there, and I think we're at the 15-minute mark. And so any questions before I move on to domain names?
Okay, so we had one quick question, actually two of them. Okay, so first one is, are you aware of a way to expedite a trademark application, maybe for a fee like copyrights?
It's a great question. Yes, I am. It's called a petition to make special, and the trademark office wants to ensure that it is truly special, not just I really, really need it because I really, really want it. So the reason has to be pretty compelling. The most common reason that I've seen, it used to be the case that you just say, I need it for enforcement purposes and the trademark office accepts it. No longer the case. Now they want a much higher threshold to be met. Otherwise, they're inundated with applications and they have to expedite all of those applications. Their examiners will never sleep. They'll do not a great job in prosecuting them, et cetera, examining them, et cetera, et cetera. Okay. So if you have a situation where there's a known infringer, that you have a good faith belief that someone else is infringing your trademark, write them a letter under the advice of counsel, hire an attorney, what have you, and attach a copy of that letter with the petition, and that will drastically increase the chances that the petition to make special will be granted. If it's just, I need it for funding, possible, but very unlikely. If you need it for a foreign registration, which I can't see how that would apply here, that also may work, but typically it's an infringement situation. Just like the Copyright Office, you have to say, I have a good faith belief that there's infringement and I believe there's threatened or pending litigation, and you fill out the reason and then pay the $750 fee. Great question, though.
Yep, and I'll actually jump in on that one too. We've been doing several of those lately, actually, and the key, it came down to the cease and desist letters, right? And attaching those as exhibits, and that was what nudged it over the finish line for the trademark office to approve it. So that's, they've definitely upped their requirements now for approval.
Exactly. And if people are curious, in my experience, so typical, I mean, lately it seems like 7 to 9 months is
I know,
probably pretty common. And then if you submit your petition to make special to Expedite, it might cut it down to 3 to 4 weeks, maybe 5 weeks, but not the 7 to 9 months. So that's shaving off quite several months, which is huge, can be huge.
Yeah, that we were seeing the same numbers too. It takes forever with the regular ones, but they're pretty quick once they approve expedited.
Exactly. And the fee is it's $100, I think. If it's one,
I think it went up. Might be. I think it might have gone up.
Under $500. It's not.
Yes, under 500. There we go. Under 500.
Under 500. Definitely under 500.
Yeah.
So
yeah.
And the form there, that's just a little box you fill out. I would err on the side of fill out more than less. Just because, as we noted, they've raised the standard to make it special. So you might as well really put in your best effort and make it as compelling as possible.
Yep, I agree with that one. Okay, second question here we have is, in copyright infringement litigation, are statutory damages and attorney's fees for registered copyrights on top of actual damages?
That's a good question. And admittedly, I'm not a litigator, but my understanding is that you have to elect. You have to elect statutory damages or actual damages. You can't basically pile them on top of each other. So, yeah, you have to choose. And if your actual damages could be higher than statutory. And if there's time, I have a war story about the importance of watching what your employees are doing wherever possible. But again, I want to be respectful of time. So we'll loop back to that, or people can email me afterwards and I'd be happy to share that. So, but great questions. Okay. We're good. Okay. This last part's pretty quick. People know what domain names are. The alphanumeric address assigned to designate a specific server on the internet. How do you protect domain names? Okay. I think this is definitely worth spending a moment on. People are searching more and more on their phones, of course, than the actual computer. I think people care less about the .net, .biz, whatever, because they're just looking at whatever search engine they're using and typing the name, and then whatever results come up, they click it, they're off to that website. I'd be shocked if many people paid attention to whether that had a www.brandname.com versus .net. So what is the point of this? I wouldn't get hung up on registering a domain name and saying, I have to use this trademark because I bought the domain name. I think that's getting things backwards. Pick a brand name that's protectable, enforceable, isn't infringing anyone's trademarks, then pick the brand name, the domain name or do them in tandem, but don't pick the domain name and say, I have to pick with this brand because I got the domain name at such a great price. You can change it to .net, .biz. A lot of times it's a parked website. Definitely consult with an attorney because the facts are so, make such a big difference in the analysis that you can't just assume, well, someone else says .net, I'm using .com, and it's Nike.net, so no one's going to be confused. We know that's not the case, but there could be situations where it's just a parked domain name and there's no issue there. So I think it bears noting that, again, select your trademarks, select a strong one, then try to get your domain name if possible. If .com's taken, look at these other ones as a way of protecting your domain. What's also worth remembering is that it's so much less expensive to register multiple top-level domain names than it is to try to get one back. So if you have an infringer, they copy your brand name, .com, .net, whatever it is, or they have one misspelling of your trademark and the .com that they've registered in bad faith to try to take sales away from your company. We're talking several $1,000s and at least several months worth of time to get it back. And that may or may not include attorney's fees. So as you see, a lot of these things are $10 for a year, $20 for 3 years. Defensive domain name is extremely important with building the IP fence that we've been talking about today. So this is just a note that there was this whole launch of create your own top level domain. Crazy expensive. I frankly don't think that many brands jumped on the bandwagon to do this. There were newer top level domains, .shoe, .agency, .foundation. Again, I think just the way people are searching on their phones or mobile devices nowadays, it's much less likely that they care exactly what the domain extension is. They just want to find what they're looking for. A lot of times apps, of course, make that very, very simple. And that's all I had for today. Happy to answer questions. And yeah, this is this flew by. Lots of fun. Love trademarks.
It certainly did. Yeah, so I don't have any other unanswered questions in the chat. If anybody has anything they want to throw in here before we sign off. I don't see any. Great. Okay, well, Jonathan, David, thank you both so much. This was wonderful and super informative and really easy to understand. Oh, I take that back. Oh, Bernard is asking Jonathan to tell the story.
Yes, the copyright story. Okay, I'll be brief. Client comes in from a referral, it's a copyright issue, and they say, yeah, we got this letter from the software company, and they're claiming that one of our employees used this third-party software without authorization, and they want $150,000 worth of damages. It's just gonna be like $1,000 or two, right, to fix this? And we think, deep dive into this, okay? The problem with statutory damages and attorney's fees is that if there's a colorable case, which in this particular fact pattern, there was a colorable case that this employee may or may not have been using the company's server at times to dabble with the program, and they accessed a larger version of the software than the company had licensed. The company actually legitimately licensed a sub piece, we'll call it, but this employee allegedly use the entire package that wasn't necessary for the purposes of the functioning of the business. So they got a letter from this very, very large software developer who definitely owns copyrights in their software and demanded north of $150,000. And the analysis is, okay, we say no, we send a letter and say, hey, we deny all claims. They sue, and they're racking up all their legal fees. If they win, which debatable, of course, they get all their attorney's fees and statutory damages, and they have to pay us. So that's a bad situation to be in. So it was definitely an eye-opening experience for this client that, wow, we have to monitor our employees, have policies in place, do not have Wi-Fi passwords for everybody in the world to see. If there's any hint of any kind of instance of infringement, address it right away. Do not delay. COVID's not an excuse. Deal with it sooner rather than later, because otherwise you'll be paying close to 6 figures. We did get that number down, and we were able to negotiate pretty favorable terms, all things considered, with extension of the licenses. But man, that's a lot of money to be spending over an employee who was goofing off on the weekends using companies' computers to do something that didn't even benefit the company directly. So that's the story.
That's a good one. I like that one. Okay, so we've got one other question here. It says, do you need to copyright a book with illustrations separately? Stated another way, the illustrations and the copy.
Wow, that's a good question. I mean, typically you would register the whole thing. You wouldn't separately break out the pictures, the illustrations separately, because it's kind of intertwined into one thing. I think so. Typically, I don't know, David or Catherine, if you have contrary experience, but you would typically register everything together.
Do together. Yeah, I usually would. Yeah.
I mean, there may be instances where you want to do it together and separately if you're going to sell prints of the drawings, illustrations separately.
That would make sense, because then you could actually enforce it, the illustrations independent of the use in the book. Yeah.
Right.
The tricky part would be what you so in registration 2, if it's the illustrations, then you have to do disclaimer, just not cover it. So, but certainly, yeah, it worth considering and looking at closely. When you register a copyright, you'll have to say if there's prior material or not, and so it depends on the order with which you file the copyright application, what you include there. But yeah, I can see again situations where you do them separately.
Correct. Oh, okay. So Richard just got back to us. Richard, we were asking for a little bit more clarification about what you meant by imprint. So if you could let us know about that. And then we have another question while we're waiting for that. It says, could you tell if a franchisor, let's see, has to have a registered trademark to be able to sign franchising agreements with the franchisees? Do you have to have a registered trademark to be able to sign franchising agreements with franchisees?
I don't know the answer to that.
I don't either. Yeah, that's a little bit out of our field of expertise. Franchise law. Okay, so we have one more that came in. If there is both copyright and trademark infringement, i.e. infringement of a word/design mark, what would be the damages? Copyright would be statutory damages. Would the trademark damages be additional?
Every intellectual property infringement would be separate damages. Great question.
Yep.
Great question.
And I agree with that as well. Okay, and then Bella got back to us about the illustration. She said prints of the illustrations are intended to be sold separately as well as in the book. So thank you. Okay. So let's see, we're still waiting on, okay, so Richard says imprints by book publishers, trademark or service mark or both.
By imprints, I assume he means like the sub-publisher name.
Oh, maybe. Yeah, Richard, I don't know if you're able to give us a little bit more clarification about what you mean by imprints.
I can say one note on trademarks and books, since we're on that topic. It's not going to address his question specifically, but if you have a single book, it's very hard to register that single work as a trademark. You typically need a series of works, chapter 2, chapter 3, trilogies, what have you, follow-ups in order to have a trademark protection. But copyright, very different. You can register just a single copyright in the text and illustrations in that one book, independent of the trademark.
That's a very good distinction to make, Jonathan.
Yeah. So if a publisher is trademarking their name, Jonathan, would that be a service mark and a trademark?
A service, I think publishing books is a service mark. I would agree with that. And you could use, if they didn't register it, they'd use TM, and if they registered it, hopefully they were using Circle R.
Okay. I don't have anything else here pending. And we're right at 5:30.
Amazing.
Okay, I think that sounds great. Thank you both.
Thank you, Catherine.
Thank you, Catherine. Thank you, Beverly Hills Bar Association. This has been a total blast. Our emails are here. Please feel free to reach out, and we hope you found this presentation very helpful, and best of luck with your new adventures.
Take care, everyone.